I call the Honourable Member Giles Chevelle.
Thank you, Mr Speaker. Mr Speaker, as the Minister presaged in her notice of motion and the speech supporting it, the Labour opposition will support this notice of motion. For those who are still processing what it means, essentially it suspends a standing order which is necessary because leave cannot be obtained because one party objects to that leave being granted for an omnibus bill to be amended in a substantive way. So there's a slightly arcane point of parliamentary procedure here. Basically what the House is being asked to do is suspend the standing order so it can simply vote either up or down on what is desired here. And the Labour Party will be supporting the suggested course of action that the Minister has put forward to suspend the standing order and to allow the substantive amendment to an omnibus bill. Now, that's an unusual procedure, and so I'm going to take some time to explain why it is that we have differed from our friends in the Green Party, not something we do terribly often, and decided to proceed in this way. The Courts and Criminal Matters Bill is essentially machinery amendments, technical amendments to legislation relating to enforcement matters. And what this bill will do is complete work that was begun while the Fifth Labour-led government was in office. The provisions are sensible in the opposition's view. The substantive legislation will introduce a mechanism into the Land Transport Act 1998 to authorise the imposition of something which will be called a driver licence stop order. This will allow the suspension of the driver's licences of people if they haven't made arrangements to pay overdue traffic penalties, and they're essentially acting as scofflaws. They're saying, look, we've got these fines, but we're not going to pay them. And in respect of a certain group of people, this is going to be the only effective way to enforce this type of payment of traffic penalties. Essentially stop the licence, take away the right to drive, and until the fine is cleared, keep that right in suspension. And there's some technical changes that the bill will introduce in order to ensure that very sensible further enforcement action or type of action will be available to the Crown. There are one or two SOPs that the Minister has foreshadowed, SOP 202 and 244. SOP 202 makes a number of drafting and technical changes to the bill. It'll consolidate some statutory provisions around the enforcement of fines and reparations. It'll streamline the procedural challenge process for unpaid infringement fees that have been filed with the court. It'll provide for the resentencing of an offender where the previous sentence or order of reparation becomes unaffordable or unenforceable. It'll align the provisions of the Sentencing Act 2002 with the Summary Proceedings Act 1957 concerning vehicle seizures. It'll set the maximum period that an offender can be detained in the custody of the court in order to complete some multiple administrative tasks, such as making a declaration as to financial capacity. It'll enhance the civil enforcement processes relating to the payment of judgment debts through attachment orders and the seizure and sale of property. And it'll update and align the property forfeiture regimes by amending the Criminal Proceeds Recovery Act 2009 and the Misuse of Drugs Act 1975. Supplementary Order Paper 244 will make a couple of drafting and technical changes in the areas of the powers of parking wardens, owner liability for stationary vehicle offences, the issue of infringement notices and the discharge of assets forfeiture orders by the official assignee. So, as I said, sir, these are technical matters. They have had broad cross-party support They were issues that were ones that began to be grappled with in the tenure of the previous government. For essentially technical reasons, these sensible changes weren't carried through into the substantive legislation, so this notice of motion is a mechanism by which that can be made to occur. It's a sensible mechanism. It's one that, although the opposition could raise a technical objection to and frustrate the government from getting its business through, on this occasion we choose not to take that approach because we do think that the substantive legislation makes sense and we would like to see it enacted. Having said those things, sir, there are one or two points that I want to make about the general program of the government in the criminal justice and the general justice area. And the Minister will recall that last week at the Select Committee I asked her whether she was concerned about the state that the sector would be left in following her departure from the portfolio that she holds, Minister for Courts, in just over 5 months. Because, of course, while we all wish the Minister well in her retirement, we are concerned on this side of the House that she's going, the Minister of Justice is going, the Secretary for Justice, who's, I think, served 10 years in that role, left a couple of weeks ago, and there are major reforms being progressed in the justice sector by this government. And progressed, sir, is the operative word, because they will not be completed in the term of this Parliament. There are extremely important issues that are being put forward for consideration by this House. Everything from reform of the sale of liquor legislation, which is now put off to the never because the Select Committee won't be reporting until the 30th of August. There's no hope that that legislation will pass in this Parliament, despite all the hopes that have been raised out there in the public for some meaningful action on that issue. There's a bail review, and I could go on at length about how unnecessary that bail review actually is, given that the previous government fixed most of the problems in the bail area, and in fact the legislation we have in respect of bail is largely pretty good, but nonetheless there's a review, and the Minister told us, the Minister of Justice, at Select Committee 2 weeks ago that he thought he might like to have legislation introduced into the House as a result of the bail review. We've had major changes to the legal aid system progressed without much consultation with the legal profession, and again the Minister of Justice told us 2 weeks ago at the Select Committee that he'd quite like to see another legal aid bill introduced to the House prior to the Parliament rising on the 6th of October. And there are many other matters before both the Law and Order Committee, sir, and the Justice and Electoral Committee. And my concern, and the concern of members on this side of the House, given the departure of 2 senior ministers, the departure of the Secretary of Justice, the fact that there's an acting secretary in place, the fact that the Minister who's just spoken couldn't tell us much.
Point of order.
Mr Speaker, I'd ask for your guidance in a matter before the House such as this as to how closely the speeches should be relevant to the matter under discussion.
Speaking to the point of order.
Thank you, Mr Speaker. Mr Speaker, this is a notice of motion concerning a bill that is within the purview of a minister who is about to depart. It is perfectly relevant, having stated the general position of the opposition, which is supportive of the notice of motion, to talk about the concerns we have around whether or not this bill will actually be able to be passed in the current Parliament, given the logjam of legislation and given the mess that the sector is being left in by this Minister and her colleagues.
Thank you. Speaking to the point of order, the Honourable Rick Barker.
I wish to make 2 points, Mr Speaker. The first one is that it is the practice of this House for a long time that when a member takes a point of order about order, that they make the point that the member speaking has done something to contravene the standing orders. It is not a point of order to ask the Chair if a rule has been enforced. It's not a point of order to say, Mr Chair, can you give me some guidance on this? That is not a point of order.
Thank you.
The second point I wish to raise, Mr Speaker, is that The government sought the opposition's cooperation in getting this through the House. We didn't play procedural politics as we could have, and I want to say to the opposition, the government whip, that if we're going to be very narrow in our interpretation, well then we might change our attitude to this. So it's going to be cooperation on one level, it's going to be cooperation on the other.
I'm on my feet. It is a wide-ranging debate, and given the notice of motion which has been outlined by the Minister, but the member has nearly finished his time, so I'd ask the member to adhere to the request.
Thank you, Mr. Speaker.
Order.
We could just withdraw our cooperation, I suppose.
Order.
Well, that's
One all. Please continue.
Mr. Speaker, as I said earlier, the opposition has chosen to seek to assist the government, despite its ill grace on this occasion, by allowing it to progress machinery reform in the justice area. My points in the last minute or two have been designed to alert the House to the real danger that despite this courtesy and despite putting this matter on the order paper, there is no guarantee that this legislation will pass in this Parliament, because there is no guarantee that it will be accorded appropriate urgency on the order paper, and there is enormous amounts of other justice legislation that this government thinks that it will be able to get through, which it will plainly not be able to get through. So, sir, with those comments and that warning, I say to the Minister, we have sought to assist because we think these are minor matters, but it would be very disappointing if this legislation was not to be progressed through all its stages, and there is a real concern that I hope ministers and others hear about the state of justice legislation on the order paper and the mess, frankly, that will be left by ministers for their successors in this area.
Okay. Honourable members, just before I call the next member, I need to advise the House that there has been an error in the voting, and the results of the two votes were incorrectly announced. Turning to the committee stage of the TV New Zealand Amendment Bill, the vote on the closure for clauses 1 to 3, the noes were announced as 55. They should in fact be 56. There was an additional error. And on the motion that the report on TVNZ Amendment Bill be adopted, the noes were announced as 55, but the correct numbers were 56. So in line with Standing Order 148.2, the vote is corrected, and this is to inform members that the record will be corrected as well. Thank you for your forbearance.
Mr. Speaker.
I